Welcome to the first of our series of Women on Wednesdays for this fall. We're having Zoom problems, so forgive us. I thought I knew what I was doing when I set this up, but obviously something didn't work. But anyhow, we're going to record this. So our first two speakers jointly today, Dr. Jamie Brown and Dr. Mary Langenbrunner. Both are senior members of Counseling and Human Services, senior faculty, and they have worked together on a project that includes legal services, and I'll let you all give a quick summary, but
Okay.
I'll let you go ahead and get started since we're late anyway, and give us a little rundown, and we will record all this.
Okay. Mary was the person years ago, about 20 years ago now, that pulled me into Rule 31 family mediation with administrative offices of the courts. And so she's been doing this way longer than I have. But that's how I got involved in working with families in the court system. And as a result of the work that we've done, primarily with either separating individuals that have never been married and have children together, or married couples that are divorcing, we have done mediations, and we get pulled into a number of other court-related things like visitations, forensic visitation, therapeutic, etc. But in 2015, we realized that there was a marriage act that had been passed and the Supreme Court had supported, and that we knew before long that there would be the issues that we were dealing with in court would need to be expanded to individuals that would now be covered and had not been in the past. Is that a good enough summary, Mary, before we get into it, of how we got into it?
It was the same-sex legislation.
Yes.
That now they're married, and because of that, there may be issues about divorce that come up. And so, yeah, go ahead.
And this just got deeper and deeper. The more we dealt with it, it got deeper and deeper. So what we want to do today is just talk about our observations and conversations. We have done some presentations on this nationally. We've also published on it, and we're continuing to do this work, but it's also just gets bigger and bigger with the people that are affected in the court system because of the court system being so heteronormative focused. So wanted to introduce you first of all to, well, there you go, our research team. And Mary and I are longtime members and been doing this since we started it about 2015-16. We started having the discussion. And we also want to tell you that we've got two new team members, Dr. Mickey White and Dr. Cynthia Chambers, who are joining us because we are broadening what we have been doing. So we'll cover a little bit about what we have been doing and then talk about the direction we're going to take this. We're going to start with couples that are either separating or divorcing that are same sex that have children, and then we'll kind of talk in more detail as toward the end about how we're broadening this.
And our role is that it's a statute that if there is a divorcing couple and they have minor children, they have to formulate a parenting plan. And oftentimes these parents can't decide because they're in conflict over quote unquote custody, which is now referred to as parenting time. So this statute says that before they can go in front of a judge to adjudicate this conflict, they have to go to mediation. So that's where Jamie and I get pulled in to having to sit with these couples and try to help them make decisions about parenting schedules.
And the sad thing that on the one hand, but it's somewhat comforting, I guess, on another, is there are just as many issues with same-sex couples as there are with different sex couples when you deal with children. Most people do not do well in navigating this, period. They just don't. So just to summarize a little bit, same-sex divorce or marriage, therefore divorce, was legalized in June 2015. Western countries were the first to legalize same-sex marriage, Western Europe and European countries, and then Canada followed suit, and we were slow. Same-sex couples are afforded the same legal rights as heterosexual couples in theory, and you'll understand why we're going to say that as we cover a lot of what we're going to cover. But these same-sex divorces are based on statutes that were totally constructed around cisgender assumptions. And so we always try to make sure that any group that we're talking with, that even not to be insulting anyway, we know that most of you all know the difference in heteronormativity and cisgender, but we always try to define that just in case we're dealing with anybody that might not be on the same page with us and might not understand that. Okay. Mary, do you want to talk about the state statutes and how they've not changed their language?
Yeah, the state and we run into, well, I haven't personally, but I have two attorneys that I work with that have run into this during, you know, when they're in litigation with their clients who are same-sex couple. But the state statutes have not changed their language. So they still refer to it in the heteronormative terminology like mother, father, husband, wife. And, you know, the attorneys are talking about this. They've got the parenting plan out and it says mother, father for the names. And of course they have a hissy fit because they're both mothers or they're both fathers. And again, it's following that heteronormativity belief that a married couple is a man and a woman. So they get into some discussions about that. But this is no longer the case. I mean, we have to be able to edit and modify the terminology on some of these legal documents so that they're more inclusive.
And, you know, we're seeing more and more same-sex couples now, of course, who file for divorce. When Mary and I first started this, and well, I'll go on and tell you that this is going to come up again as we speak. We wanted to talk with the judges we work with. And that was interesting. Most of them had given no thought whatsoever. A couple of people flat turned me down and said they were not going to talk about this when I approached them. And these are people I work with all the time, but they, you know, we said, you know, you say same-sex couples and you're in a very right-wing area and you have a lot of these judges that just about die over the topic, period. The ones that did sit down and speak with us, though, 3 out of the 4 either, I would describe it, and Mary, you help me here, either as disinterested or, you know, if they don't meet the criteria that's already set out with what we deal with, and if it's not the bio mother, the bio father, that's too bad. You know, there was not a lot of willingness. They were willing to share their opinions, but there wasn't a lot of willingness to rethink some of what we wanted them to rethink. We did have one judge, and we'll talk about him later, who is, we call him our hero, that is a cisgender, straight white man that is wonderful. He has been open-minded, and we will give some time to him in just a little bit. He was the one beacon of hope as we started having these discussions with these judges. Children of same-sex marriages present a problem during divorce because of parenting and the legal terms for parenting. And we have to worry about that because a lot of these couples were together before they were married, and these children were products before they were married. And now, even though they are married, they're not, both parents are not considered legal. Then there's the issue of adoption, where at one time before same-sex marriage came about, they would require the bio parent to give up their rights so that both of them could adopt the child, which leaves the child in limbo, and it's a very scary time period. So unless the child's born during the marriage and both parents manage to get themselves on the birth certificate, the non-biological parent has no legal parenting rights. And from my understanding from folks that I've spoken with, some hospitals give these people a fit about even getting the name on the birth certificate, even though they're married. So even though people may go into a relationship or a marriage, both agreeing that the child is going to be theirs and raised together, and they're both the psychological parent, even though one might be the bio parent, in some instances, neither one are the bio parent. It is a real mess. So judges typically just default to the statute related to unmarried, unbiological parents and say the mother is the primary parent because that's the only one we can prove had the baby. So unless you go through and have DNA tests, which is not going to help same-sex couples in most cases at all, you've got a problem.
If it's, if there's an unmarried couple and they're typically non-residential when we see them, so they had this child together and they split up, and now all of a sudden dad, the father of the child, wants parenting time, they have to come before the judge, and first parentage has to be established. So if dad's name is not on the birth certificate, they can either come before the judge and they both say, yeah, he's the father, and then an order is put in that effect, or they have to have a DNA test to prove that he's the father of the child. Then they can do a parenting plan. But otherwise, mother has all the rights if they've never been married.
So as you can see, it's messy and it's scary. And it's particularly scary when someone has been the parent to a child, been there, for when they start school, been there for when they're sick, been there in every way as the psychological parent of this child. And then because the law has the statutes and the law and the way it reads have not caught up with the fact that these people can be married, they can have children, and that both of them do not have to be genetically connected to the child, or even either one of them necessarily genetically connected, biologically connected to this child. So, it's a mess. And so the thing that we are running into is those parents just, if they haven't gone through adoption, simply have no rights. And we'll tell you an innovative thing, Mary will tell you about that later, that our wonderful judge has done recently that we're very proud of. Some of the things that we really have recognized is that attorneys and mediators and judges absolutely have to become informed on the issues related to these couples. And the education goes beyond just the legal part of the education. I think one of the reasons the judge that we've had success with has been open-minded and has worked toward a better outcome is because he was willing to listen to the personal stories and the personal issues and think about, why what was going on just didn't make sense. Judges need to really be pushed, or you can't push a judge, but they need to be encouraged to appoint guardian ad litems who are informed about LGBTQ and the community and the issues that need to be resolved, because they just don't know. It's not that most of them are trying to be evil, but as you know, most judges are older folks, and most of them don't have any experience with this unless it might be an issue in their own families. Otherwise, they don't. Judges might consider suggesting that the statutes be reworded to be more inclusive. And we've really pushed for that. And we've gotten several mediators of the same mind, that they get that. I think as always, attorneys are a challenge because they see things their client's way, and they're open to it if it works toward their client's benefit, but not if it doesn't. But the problem is it needs to operate toward everyone's benefit. And that's what we're working for, trying to get people's attention about. And then the parents may need friends of the court to explain the issues related to what their divorce might be. In other words, they need someone that can help them better understand, as well as the court system. We're working in both directions, because nobody goes into a relationship, or most people don't, thinking I need to be prepared in case this doesn't work out. What's going to happen with my child or children. That's not the mindset people have. And so they need to not be blindsided. So just like any couple might need premarital, pre-relationship counseling, that would be a great idea to let people know the obstacles they might come up against.
And something else that's kind of interesting is that most of the mediators, at least in our area, are attorneys. And attorneys don't know anything about families, parent-child relationships, attachment. So they, I think it's hard at times when these attorneys are serving as mediators to keep that mediator hat on and not, be flipping their attorney hat on.
Well, you know, they're trained in an adversarial relationship, and we're trained in trying to bring people together. And so, and one perfect example of what we've noticed, Mary and I walked out of a training in Nashville one time after we drove all the way down there because they made fun of us because they asked if there was anybody in the group that absolutely didn't do shuttle mediation. And we raised our hand and they said, well, there's two true believers. Well, we don't do shuttle mediation. I would if I was dealing with domestic violence or something that was, you know, that some reason that they shouldn't be in the same room together. But what Mary and I find is that we want all parties in the same room. And so that whenever they mediate something and agree to it, that everybody's hearing the same thing. You can just imagine when you put people in two different rooms and shuttle back and forth between those rooms, the story that gets told to get somebody to agree to something might be shaded just a little. And then when it goes back, that might be shaded just a little. Well, you may get agreement on paper, it won't stick because everybody's not sitting there agreeing to the same things. That's kind of a different caveat than what we're talking about, but it's just part of that respect and trying to get people to work together and also come up with an agreement for these children and the sake of the parents and the children that will stick.
And most attorneys want that shuttle mediation where they separate the parties. So attorney A and his or her clients in this room and attorney B and his or her clients in that room, and the mediator has to go back and forth, which to me negates the whole purpose of what mediation is.
For years, attorneys weren't mediators. It was only people that had certain degrees, at least a master's degree in certain areas that can be considered behavioral, family related, that were mediators. But in more recent years, the attorneys wanted to become mediators because it was court mandated that everybody had to go through mediation. And not to be cynical, you know, that's money on the table. People like Mary and I work pro bono or at very reduced fees. And so we get a lot of people that can't afford the attorney because that's what we're here for, though. We're here as a service. It's not our career. It's a sideline that we do to try to benefit the families in the community. But that's the reason, in my opinion, and I know that sounds cynical, but I don't think many of them had a mediator's heart is the reason that they came into the idea that they wanted to be mediators. Some of the things that we really feel like have got or need to happen is that judges might consider suggesting a judicial conference that could be a focus on those issues related to same-sex divorce and the possibility of suggesting changes. And now, given the direction we're going, we would expand that to LGBT issues in general, you know, related to families. This is going to become more and more messy as time goes along if they don't get this straightened out. And when attorneys and mediators are formulating parenting plans, they really need to be cognizant of inclusive language while preparing them. And, you know, that just makes everybody more comfortable. And I don't know of anybody it should make uncomfortable to have inclusive language. It's a form of communication that avoids using words or expressions that has assumptions that would stereotype, demean, or exclude people. And so one of the things that we've been interested in is on the parenting plan, you know, Mary spoke about how it says mother and then father. Well, we were talking with a long-term mediator in the Johnson City area one day about wanting to change that, the way this is written on these forms. And then we got to laughing about that if you're like dealing with a heterosexual couple, they'd be fighting over who was parent A and who is parent B, or who's parent one and who's parent two. So, you know, we need to come up with some type of language that doesn't negate one of the roles, you know, in who's parenting these children, whether it's parent A and parent one, or just something that seems equitable. And I don't necessarily have an answer for that. If any of you all have suggestions, I'd love to hear. And then same-sex marriage regulations have already outpaced the statutes in keeping up with the changing family dynamics years and years and years ago. Even when Mary and I were still in school, the National Council on Family Relations did away with the quote traditional definition of family and made it an inclusive, supportive process of people that work together, live together, support each other in a number of and variety of ways. Our court systems have not, of course, kept pace with that. And family court is looser than other courts in terms of judges having more leeway in terms of how they interpret the law and what they do with it. But that would mean that everybody needs to be educated and on board for this to be a fair and inclusive process. It's not like criminal court or even civil court. Family court's different. You know, judges do have some leeway, but again, we see a real need for that to happen. You want to, and Mary will talk to you about Judge Louderback because she works with him
There
all
he
the
is. Yeah, he's adorable. So when Jamie and I were interviewing these judges and collecting some data for the information that we have now, I interviewed Judge Lauderback. And what Jamie and I did was make up a scenario about a couple, two women that had been partnered, and they adopted a child. Well, no, one of the women had the child, was the biological mother of the child, artificially inseminated. They had the child, and of course that predated the legislation where same-sex marriage was implemented. And then the partnership broke up and they went to court, and the judge said to them what Jamie had explained, that the only way that you can do this is to give up rights altogether, and then you both can adopt and be put on the parenting plan, which they never did. And long story short, the other mother that was present in her daughter's life for 3 years has absolutely no parenting rights now. So the biological mother has the child, has even repartnered, and I think her partner has adopted the child because they're legally married now. So anyway, we presented that scenario to these judges and asked them how they would adjudicate it. So that, you know, hypothetically, they had these two mothers in front of them. They both wanted parenting time, and the judge had to make a decision about how to settle that. And Judge Lauderback was just stymied, and he honestly didn't know what the heck he would do, but he appreciates the fact that the non-biological mother served as a de facto or psychological parent for this child and wanted badly for this mother to have parenting time. So anyway, after that, he said, I have to go to a judicial conference next week, and I'm going to present this to some of the other judges that are attending it. And he got back with me after the conference and said, every single one of the judges said that they would award the biological mother, the one whose name was on the birth certificate, parenting of that child. And since that time, he's been really, really involved with some of the issues related to these same-sex couples that are divorcing. And he had a case in front of him about 3 months ago where it was a married same-sex couple, both females. They had a child together. They had the child prior to the marriage. So, you know, since that time they got married. The child's name was not on the birth certificate. The child was never adopted. And the biological mother's attorney was fighting hard for her to be the biological mother and get exclusive rights to the child. And then Lauderback said, well, I mean, one way we could deal with this is for this other mother to adopt the child. And neither of the parents had issues with that. So he stopped the proceeding and did the adoption so that they both had parenting time, which was just unbelievable. Another thing too that he's done, every year, I'm a member of this nonprofit organization that's called the First Judicial District Assistance Corporation. And it was started when judges were 15 years ago. It's been in existence for 15 years. The judges would get these couples in front of them that were just high conflict. The litigation just could never be resolved, and the judges didn't know what to do. So they wanted access to some mental health professionals that could interview these parents and conduct what we call a forensic evaluation with them, just, you know, to collect data, get reports, look at the data, interview the couple, sometimes the children. And because of that, we started sponsoring a seminar every year where the attorneys and mediators come together to collect their continuing ed certificate points, to be recertified or licensed or whatever it is. So anyway, this year, Lauterbach is going to present at the conference on issues related to same-sex parenting and custody in front of these attorneys and mediators. And then we've also recruited Dr. Mickey White, who Jamie mentioned at the beginning of this, to do a presentation on legal issues as they relate to transgender children during divorce and separation. So again, we're trying to get the word out, and Lauterbach is the one that really pushes for this. So that's good news.
Yes, and he already had us present what we had found with the judges we spoke with at the one, was it last year, Mary?
Yeah.
And then he also had Dr. White present at that one as well. So it's, his support is not just, he's not just out there talking about it. He's making a difference where the rubber hits the road. He's making a difference in terms of taking on, and it's not easy to take on the attitudes of some of these judges, but he is willing to keep that conversation going and to make a difference in his own courtroom, which I think is such a wonderful thing for us to see. And hopefully, I think he told Mary originally, and Mary both tell me, I thought it was hilarious when originally when everybody was so excited about his attitude, he said, "But now I don't want to become famous over this." So he meant he didn't want to establish case law. He didn't want to be the first one out there, but I'm afraid he's done it. That might have not been his intent, but he's already done it. And somebody had to. Somebody has to. And the good thing about it is once something is codified in the law and a case goes through and that has been the finding, it does become precedent, or at least it used to. I don't hope it still will. It's supposed to. And so other judges, when they get these cases and someone does that search through prior cases, his case will come up. And if it has not been overturned, then that would be their precedent to make a decision in a better direction than what we've seen going on in the past.
Yes. Yeah.
So our next steps are that we want to get the attorney's perspectives. And again, that will be somewhat challenging, although I find those perspectives change according to who they're representing many times. They are supposed to be the best representing their client in his best interest, but also they need to understand this better when they come up against it so that they can be more humane in the way people are treated. We also need to begin to identify advocates for the court system, and the fact that Dr. White has been involved in some of the things that we're talking about and will continue to be. These are people that the courts can go to. They already, what Mary and I have found, because we've been long-term mediators, the courts are desperate for input from anybody that might know anything. And they will ask us to do things all the time. And I say, that's not my expertise. I don't do that, and they say, well, we don't have anybody to do it. They are so desperate. And the more we can get the word out to people that would be advocates and that could help in the education process. And once a judge asks for someone to be established as a friend of the court or an expert or whatever, they do most of the time listen to those folks, especially if it comes from the judge instead of the attorneys. Many times the attorney's just going to find and pay whoever's going to represent their client's interest the best. But if the judge asks for it, it matters. And so that, getting to these judges is critical.
And the judges don't, these experts don't hesitate to be supportive. Judy, you may remember Tom Schacht, who was in the College of Medicine. Well, he's the forensic evaluator with this court clinic that we do. And these judges call him 15 times a week asking stuff.
Gosh.
And he's very willing to share. So they need.
And what happens, Mary and I both have done this for a long time. And I know one time I had a real issue with a client that they had sent and was really being abusive to the women that I had working with them in a visitation capacity. And the judge said, hey, listen, they solve problems for us. That give them what they need, give them whatever support they need. So that's kind of the attitude that they have. So we know that we don't want to overplay our hand, but at the same time, anything that we can do to encourage them with Lauterbach's help to be more open to individuals that could give them some insight into what this family is dealing with in the best interest of the child. And I say that, in air quotes, because I hear every case I'm dealing with about the best interest of the child, and then watch judges lots of times do something that has nothing to do with the best interest of that child. It has to do with the competing adults in the court situation. But the more we can get people on board to understand that we need these advocates, we need people that understand what these families and children face. And this is including transgender children and children that are questioning anything that they need to be educated in this. We are moving toward wanting to do interviews with LGBTQ plus court-involved individuals, as well as just same-sex couples. And that's the direction that we're going to be going with the next steps of our research, which Dr. White and Dr. Chambers are going to be working with us on. And we're real excited about that because we don't want to lose the personal element. We get so focused on court and the outcomes of these cases, and every one of these cases have families involved and children involved. And we need to make sure that we are always not losing sight of that. And this is just something we wanted to share with you. Mary found this and we just think it's adorable. It's something we use when we're trying to help people who do not understand the many facets of people's identity. And the genderbread person, one of the things I love about it is you can look at that if you're 5 years old or if you're 90 years old. And it helps you. It helps you. So that's it's just a fun little thing that we use, that we just wanted to share with you. If you haven't seen it, many of y'all probably already seen it, but if you haven't seen it, we just think it's a fun thing to have available when you're trying to speak with folks that might not be on the same page.
Yeah.
So other considerations, we want people to try not to make assumptions about gender of someone's partner or race. LGBTQ plus couples with your language. Feel free to bring your husband and wives. Instead, you need to be talking about bring your spouse or your partners. Acknowledge that children need the love, support, and presence of both parents in their lives. And we need to set aside our biases as to how this should look, how families should look, how relationships should look. If it works for them and children are happy and safe, that's all that matters.
Yeah, that's it.
So we're interested in your comments, insights, questions to what we presented.
This is fascinating. I'm really impressed. And it's something, often decisions are made without considering the legal backlash of what might happen. And certainly it's children who, in the breakup of any couple, it's how the children are affected. So I think this is wonderful. Chelsea, do you have anything you'd like to?
I mean, I was familiar with some of this from friends who are unmarried and have children, and thinking about, they're still together, but thinking about how they experienced like the hospital scenario, right? Yeah. And how they were treated. My friend was made to watch a video about like, don't be a deadbeat dad. because they weren't married. That was a requirement at the hospital, that he had to watch this, like perform this like training that was like, don't be a deadbeat dad, even though you're not married. And, it was a planned for and wanted child.
I do mediations in juvenile court with unmarried, non-residential parents, and Judge Green insists that these people get a parenting plan. And I mean, I did one last week where the couple had the child, they were still living together, but just in case they broke up, they wanted to do a parenting plan, which, I mean, that just freaked me out. But anyway.
Well, it's almost like, a foregone conclusion, this isn't going to work.
Yeah, well,
You
yeah,
know, it's
based,
like, oh,
based on your comment, Chelsea, that's for sure.
yeah,
Yeah.
that-
Yeah. I mean, that was like how he felt. Like he was like, wow, I am like, it's like I didn't, just because we're not married, I'm
Got
not committed to this child.
Yeah,
It's
Um,
just insulting.
yeah,
Yeah.
yeah. And I mean,
and
it's
hurtful
interesting.
at some level.
Obviously, they're not going to do that to the woman because she's in there, like, birthing the child.
Yeah.
Right.
But it was such a gendered moment because he said it was very much phrased around like dads. So even if it was like a same-sex couple and they weren't married,
Yeah.
they would, I guess the woman could still go in and watch some Don't Be a Deadbeat Dad
What
videos.
was that in one of our hospitals?
No.
Oh.
This was actually in South Carolina though. But he said he had they had one child in California and one child in South Carolina. And he said South Carolina was worse, but California still involved a lot of like extra legwork
Oh,
to
okay.
sort of be included in the process.
Yeah.
So cool. I was like, I don't have any feelings about divorce and children, but I do love the way our legal system is constantly trying to reinforce particular models.
Stereotype. Yeah.
And unfortunately, so much of this stuff, the thing that scares me and everything that Mary and I have been working on and talking about, when we first started it, we had a lot of high hopes because, I mean, same-sex marriage had just been passed and we just saw this as exploding and being better and better and more inclusive. And people, I guess I knew there might be some pushback from some of the judges, but that ingrained attitude. And like I said, 2 people told me, no, they didn't want to talk to me at all about it.
Yeah.
And one of the judges told me no, that she
Yeah.
didn't have anything to say.
Yeah, and the 2 that I did interview were pretty open, but again, very similar to Mary's other judge that she interviewed, other than Lauterbach, was that I would just go with, they didn't say this, but it's what it is, the heteronormative focus of the way things always are, and that's just the way it is. And and they felt, I guess, that was safe. And I don't know if it pushes up against their belief system as well, which is not supposed to happen, of course, in court, but
No.
we often see it happen. And it has been disappointing, to say the least, with some of the legal decisions that have been recently made, and scary that we are not in a progressive line of more and more rights for people. It seems like, sometimes it's been very slow, but at least the trajectory has always been toward more rights and more inclusion. And now we're seeing things that scare us about whether that's the case.
Yeah.
Or continue to be the case.
I mean, there's some states that are already proposing rescinding the same-sex marriage legislation. So that's scary.
And the states that are denying medical services to
Right.
transgendered individuals,
Yes.
and blocking parents from making decisions that could be helpful to children that are transgender. So there's a number of issues that, this is just the tip of the iceberg in terms of the things that we're going to have to deal with legally.
Yeah.
Well, thank you all so much. And I'm so sorry that this Zoom did not work the way it was supposed to, but at least we have it recorded, and I'll send out to as many people as I can how to get into the recording. But I've got to go back and edit the other Women on Wednesday meetings I've set up now to
Oh,
get
yeah.
rid of this passcode. I thought I
Make sure to hit waiting room. And
Waiting room.
I think the way the system's set up now at the university, it bypasses it.
okay.
The
Yeah.
code.
They changed some settings over the summer, Judy.
They did.
Yeah.
did.
Yeah,
I discovered that the hard way as well.
Yeah,
As in I was sharing lots of
I'm
links.
so sorry because this was a fabulous presentation.
Yeah. Thank you
Well,
so much.
We
You're
were so
welcome.
comfortable with you. It's so good to see you, Chelsea.
Yeah. Nice to see you.
I was singing
Nice
your
to see you.
praises to Mary about how well you were such a delight last year. And Judy, it's so good to have you this year. I mean, it's
Thank
really
you.
nice.
Yeah.
Hey,
No one is more delightful than Judy. So
Oh, I don't know about that. Well, and I was going to say, the women and gender, the Women's Center they're having an open house right now.
Yes.
So that may be why we
Oh, you're right. That's
Because I
right.
did send out that passcode as quickly as I could to the steering committee
All right.
and,
Yeah, that's fine.
but that could be the Women's Resource Center's they're having an open house. And
You
they
just
probably had food and we didn't, so
Yeah.
and you just witnessed the only way you get Mary and I to agree to a recording.
you did a fabulous job. I am really impressed.
Oh, well, thank you all so much for
Right.
having us and
You all
listening.
have a
Thank
good one.
you.
Bye-bye.
Thank
again.
you.